Bom dia. That is the beginning and the end of my Portuguese. Thank you, Julita, for those kind words in your introduction. Thank you to Nancy Cardia and Sergio Adorno for inviting me to participate in this program. My great pleasure in returning to Brazil, where I have some good friends, is mitigated only by the somber nature of the topic under discussion. My talk will be rather different from those that have preceded it. I am not a moral philosopher. I'm not a lawyer with experience of international jurisprudence. I am a sociologist first and a criminologist second, and I have spent most of my career doing research in prisons, particularly concerned about issues of maintaining good order and discipline in difficult circumstances. And I have specialized mainly in looking at systems where there is heavy use of maximum security custody or so-called super-maximum security custody. As I think Julita said in the introduction, although I didn't have my headphones on, so I can't be sure what she said, she referred to my experience in Brazil, which very briefly is this. I first came to Brazil as an advisor to Amnesty International, and I contributed to a number of Amnesty reports on conditions in delegacia and in prisons, and subsequently in juvenile facilities run by Fevereiro. Since then, I have been involved in a prison improvement project here in the city of São Paulo, so that's my experience here. And I was delighted to work on that occasion, not only with Julita, but also with one of our excellent interpreters today. It seems to me that Brazil is probably not much involved in the interrogation of international terrorists, and most of the discussions thus far have been specifically about the war on terror. Brazil does, I know, have significant problems in relation to the running of its prisons, and that is not without some very explicit instances of torture in that domestic context. And I got the sense from yesterday's discussions that many of you are interested in the way in which these kinds of debates reflect back on what happens in prisons. So my talk is about the war on terror and the legitimation of torture in prisons. And what I want to do is to explore some similarities between what happens to suspected terrorists in places like Guantanamo Bay and suspected gang members in prisons who are held under due process of law in so-called supermax prisons, and the particular prison that I will talk most about is Pelican Bay in the state of California. The question I really want to pose is, does what is regarded as legitimate in one context, does that legitimate what happens in the other? And Conversely, if we come to the conclusion that what happens in one context is not legitimate, does that and should that reflect on what happens in the other context? And so the kind of debate that we are now having is about the war on terror could impact upon what happens in domestic situations. I'm greatly having to abbreviate my talk, but this is the plan of the paper. I'm going to talk very briefly initially about international and domestic law. The main part of my talk is going to be about supermax prisons in the United States. And then in a third part, I will attempt to draw out some similarities with what happens in Brazil. I was going to also talk about Russia, and I was going to conclude with some considerations, at least, of alternative ways of dealing with these problems. I think there will be no time for that in my exposition. We may possibly refer to some of those issues in the questions. I'm sure I don't need to spend any time discussing the International Covenant on Civil and Political Rights. Just to remind you that it's Article 7 that bans torture and cruel, inhuman or degrading treatment or punishment, and Article 4 insists that there is no derogation even in times of public emergency. The other main instrument is the International Convention Against Torture. Article 1 of that convention provides a pretty comprehensive definition of what is meant by torture. But what I want to draw your attention to particularly is that that same paragraph that defines torture explicitly excludes pain or suffering arising only from, inherent in, or incidental to lawful sanctions. Now that's a very important exclusion, but it's important also that one takes note of the precise wording of that to explore to what extent what happens as a result of lawful, in inverted commas, sanctions, whether what happens under that is necessary and inherent in that process. The other articles on the screen relate to other important provisions in the Convention. The only one I want particularly to draw attention to, I think, is Article 2(1), which requires all states who are party to the Convention to take all effective measures to prevent torture. It doesn't actually say all, but it refers to legislative, legal, administrative, and other measures. And part of the argument that I want to develop here is that, in my view, the United States has not done all that it might reasonably do under that article. The United States has ratified the covenant, and when it did so, it made a very important qualification. It ratified it only insofar as the prohibitions under Article 7, if what was meant under that was the same as what was prohibited by the 5th, 8th and 14th Amendments to the Constitution. Now, there is overlap between the Convention wording and the American constitutional protection against cruel and unusual punishment, which is the Eighth Amendment to the Constitution. Although there is overlap, those terms are not coterminous. They have different meanings. And there's a strange irony, actually, in the way in which they are interpreted. Under current US court interpretations, it is actually necessary to demonstrate intent by officials in a way that frequently interpretations of the international conventions in Europe has not required the demonstration of intent. That is to say, there have been findings in Europe where the consequences of the treatment can be deemed to be cruel, inhuman or degrading, regardless of the intentions of the officials. And certainly we in England have been on the receiving end of judgments of that kind. Nevertheless, since the International Convention quite specifically refers to pain that is intentionally inflicted, it is right and proper that both the Americans and all of us should look at the state of mind of officials in determining whether what goes on in prisons amounts to torture or inhuman or degrading treatment. Because I have included the notion of legitimation in my title, I want just to say a few words about the concept of legitimacy in the way in which I use that term, which may be different from some others. I apologize to all of those of you in the audience for whom this is old hat, but in case you are not familiar with the way in which this is used in political science and in sociology in particular, the concept of legitimacy derives essentially from the work of Max Weber. Max Weber argued that power resting on force is inherently unstable and it cannot persist over time, that if a power relationship is to last over time, it has to be transformed into legitimate authority. And Weber identified three kinds of legitimate authority, whereby the people followed the leader because they believe either in a traditional kind of authority, which is the kind we do it like this because we've always done it like this, or because of a belief in charismatic authority, the belief that the leader has special powers that demand that we follow him through the power of the charisma. And finally, and most importantly, and the most stable, is rational legal authority, where people follow what leaders and governments do because the commitment in the relationship is bound by law, the rule of law. It's limited in its scope. It's specific in relation to well-identified activities and so on. And importantly, the people have some say in the nature of the rules and the nature of the relationship. Now, what is important in Weber's notion of authority is that if you take Weber seriously, authority is delegated, if that's the right word, upwards. It's not something that comes from above. The moment the people decide that the leader is taking them astray and outside the scope of traditional authority, charismatic authority, or rational legal authority, then the authority disappears. The legitimacy disappears. And what happens is that the leaders fall back on coercive power and force. In the way in which I want to use this, it's important to take on board the modification proposed by David Beetham in 1991, who added another layer to Weber's definition. For Beetham, it's not enough for this to be legitimate and stable simply because the followers believe in their leader. For Beetham, it is also important that the leaders who lay claim to authority must be able to demonstrate, to show that its use of that authority is justified, or at least justifiable. So there are these two elements essentially involved in stable use of authority. I now want to turn to the prison situation. In recent years in England, sociologists have widely used the concept of legitimacy in studying prisons in an attempt to better understand the way in which most prisons in our country, most prisons, most of the time, are reasonably orderly, despite the fact that there are many, many more prisoners than there are staff. Staff are always outnumbered, but the prison goes on. Both sides, both staff and prisoners, have a vested interest in stability. And both of them, as it were, come to some kind of agreement that the rules are fair and appropriate. When prisons end up in riots and disturbances, that is pretty good evidence that legitimacy within that institution has disappeared. And we had a lot of riots in England and Wales in the 1970s, the 1980s, and culminating in 1990 with the biggest riot in our history, in which there was a major debate. And it produced a report by Lord Justice Wolfe, which synthesised what had by then become a near universal consensus in Britain between prison officials, prison reformers, prison researchers, and prisoners and prison staff, that our system had got hopelessly out of kilter. It had for too long emphasised security and control and had insufficiently paid attention to issues like justice and fairness. And Wolfe's report essentially said that if we want to avoid trouble in prisons, then prisons have got to be made more legitimate, and the relationship between security, control, justice, fairness has got to be rebalanced. And to a large extent, that has happened in Britain. I have looked at the American literature on prisons, and you scarcely find any discussion of the notion of legitimacy in the way in which I have described it. And American prisons have had a pretty tough history. During the 1970s and the 1980s, there was serious loss of control in many US prisons. The reasons are too complex for me to even begin to analyse them here. They had to do with the changing racial composition of the prison population and the emergence there, initially for self-protection, of gangs of prisoners that themselves were racially based. There was the white supremacist group, the Aryan Brotherhood. There were Latin American groups, the Mexican Mafia and the Nuestra Familia, and black prisoner groups such as the Black Guerrilla Family. The response to those problems was initially for states to send their most difficult prisoners to the federal penitentiary at Marion, which had replaced the infamous Alcatraz. And for a time, they held their most difficult prisoners in Marion Prison, and particularly in H Unit in Marion, which eventually got to the state where it was in a complete lockdown. Prisoners were just locked into their cells all of the time, no programs, nothing, and only came out to have shower or exercise. In a famous report on the Marion lockdown by David Ward and Alan Breed, there was some analysis of the problems, and David Ward argued at that time that this was no proper solution, that you can't maintain a lockdown indefinitely. Sooner or later, it has to open up, and prisoners and staff have to find a way of living together in relative peace. But what actually happened following the Marion lockdown was that individual states looked at what the feds were doing in Marion and effectively said, we shall build similar institutions in our own states. And the prisons that they built, especially for the purpose, were supermax prisons. And they burgeoned. And today, as we speak, there are more than 20,000 prisoners in the United States who are held either in a new federal penitentiary, supermax, administrative facility in Florence, in Colorado, or in more than 30 states have built their own supermax prisons. Supermax prisons are said to be for the worst of the worst, and that's deliberately emotive language. It conveys the impression that the prisoners in supermax are little more than animals, that they may be regarded as near subhuman, and frequently the language used by politicians and officials comes quite close to the way in which suspected terrorists are described. In fact, the notion of the worst is clearly not a scientific concept. It's a concept that has no value whatsoever. 20,000 prisoners can't all be the worst of the worst. And the worst prisoners in, say, Wisconsin are likely to be shining stars compared to the worst prisoners in California, if one used the same yardstick. The reality is that some of the prisoners in supermax do meet the criteria, a great many do not. The other element in the philosophy is that bad behavior gets you in, good behavior gets you out. It sounds simple, but who defines the behavior, either bad or good? I have interviewed prisoners in Supermax who have committed the most fearful atrocities that anybody would wish to contemplate. But they are there alongside sometimes juveniles and in many other cases prisoners who have been transferred from sometimes open prisons direct to Supermax because of minor assaults. Good behaviour gets you out. How can you behave well in an environment which deprives you of all opportunities to do anything or any responsible behaviour? That possibility is denied. And in fact, the judgments about how you get out are frequently made by low-level prison officers who themselves have very little training. What are the characteristics of the custodial situation? Well, typically these prisoners are held in very high-tech prisons, purpose-built, no longer the big open tiers that one sees on all the old prison movies. Now prisoners live in what are referred to as pods, and a pod may contain 25 or 50 cells. Each prisoner is kept separately from other prisoners. They remain in there for 23 hours of the day. They only come out to be taken to the shower or to a visit. Whenever they come out of their cell, they have to back up to the serving hatch, put their arms through, they're handcuffed behind their back. The guards then come in, put chains on their feet, chain around their belly, frequently a spit mask over their head, just in case they've got HIV. And they are marched. Prisoners were brought to me routinely in that way when I was interviewing them in the States. And during the interview, they were chained to the table. Guards only ever go into the pods either to poke meals through and to retrieve the tray, or for purposes of making cell extractions. If they're removing a prisoner from their cell, the prisoner is always outnumbered by 5 or 6 staff to 1. For more routine things where there is no misbehaviour, as it were, they are always outnumbered by at least 2, but often 3 to 1. What the Americans have now shown is that it is possible, contrary to the received wisdom that David Ward talked about, that you can't maintain a lockdown indefinitely. They have shown that it is possible to maintain lockdown situations permanently. And they have shown that it is possible to organise the system in such a way that the guards, though they are a tiny minority in the overall population, they have controlled the situation in such a way that whenever prisoners come out of their cells, the guards are in the majority. There is no longer any need for the kind of legitimation from below that I was talking about earlier. No need for staff and prisoners to develop any kind of mutual understanding about how things go on. Indeed, there are no need for them even to contact each other, apart from the most meagre situations where orders are given. In those circumstances, the basis for legitimacy can only come from outside bodies, it seems to me. It has to come from the courts or some other monitoring institution. I must tell you about the most important case, the single most important case that did go to trial, and it concerned conditions in Pelican Bay, and the case was Madrid versus Gomez. I would urge anybody who has not read that very lengthy judgment to do so. As I've said, the US courts apply a state of mind criterion concerning intent in forming a judgment as to whether or not it constitutes cruel and unusual punishment under the Eighth Amendment. Now, the thing I want to concentrate on particularly is the way in which gang members are dealt with, because a high proportion of prisoners, certainly in states like California and one or two others, the main reason that they get to Supermax, in a place like Pelican Bay, is because they are suspected of being gang members. Now, if this were to happen in Britain, we might very well decide that we need to remove gang members, known gang members or suspected gang members from the rest of the population for administrative purposes in order to protect the rest of the community and to make sure that staff are not assaulted. But in the United States, they go further than that. It is quite specifically the intent of the Department of Corrections in California to break the will of gang members and to persuade them to debrief, by which they mean to confess their membership of the gang, to give information about other gang members. And in that way, they hope to break the power of the gangs. Excuse me. I have sat in on some of those debriefing processes, and prisoners, the suspected gang member is encouraged to believe that if they do debrief and give the information, then there will be a better life for them. They can be removed from these conditions. If they do debrief, however, the better conditions frequently turn out to be no more than another part of the same prison where they are now held in protective custody. Why? Because deliberately and with intent, the authorities then pass the information that the prisoner, the gang member, has given to the other gang members in the prison because they believe that this is the only way that they can trust the word of the prisoner who has debriefed and given them this information. What this does is to put a price on their heads, quite clearly. And many prisoners then spend the rest of their term in custody in protective custody. I'm fast running out of time. The Madrid trial exposed widespread abuses, including the massive use of excessive force, including lethal force. And when you go to Pelican Bay, and if you're allowed in a pod, you're invited, as I was, to put on a flak jacket. And there are big signs on the walls which say, "No warning shots." So many people have been injured as a result of ricocheting bullets used inside the prison. Now, intriguingly, in the Madrid case, the gang members did not bring an action particularly concerning this whole debriefing and interrogating process. that wasn't one of the main issues. They did get some redress about the liberty interest under the 14th Amendment as to whether they were correctly classified to go to a supermax prison. The Madrid judgment did find that there was excessive use of force, including lethal force. And it did decide that the conditions in Pelican Bay did meet the criteria of cruel and unusual punishment, but only in respect to prisoners who were already mentally ill or who were deemed to be in danger of becoming mentally ill. And that had a good consequence in that the Department of Corrections had to look very hard at its mental health policies. But it did not find that the conditions were unconstitutional for prisoners with normal resilience. I don't have time to give you the exact wording of this, but it was something along the lines that said, although the conditions here hover on the very extreme boundaries of what any human being can tolerate, because it doesn't reach the level where all prisoners might suffer from mental illness as a result, we will not intervene with the policies of the Department of Corrections because of the wording of the Eighth Amendment and the relationship between federal authorities and the states. And so that was the finding of the Madrid judgment. I'm very quickly going to get on to other sources of protection, and I fear I'm not going to be able to address directly conditions in Brazil, except through questions and answers. I asserted at the beginning that, in my view, the United States has not put in place appropriate measures to protect people from inhuman and degrading treatment. So far as I am aware, though there are people here who may be able to correct me, there are no independent bodies in the United States specifically charged with monitoring what goes on in the prisons. The main avenue for redress is through the courts, but that does little by way of prevention. There are two bodies which do play a role. One is the National Institute of Corrections, and that has an advisory role and has indeed set out some guidelines about the way in which these institutions should be run. The difficulty is, once you start writing guidelines for how these institutions should be run, you are accepting the premises on which those institutions were founded, and there is a tendency here, analogous to the debates we've been having about torture and as to whether torture light is acceptable. Certain kinds of activity then become routinely institutionalized through that process. The other body is the American Correctional Association, which is essentially, as its name suggests, an association of correctional bodies themselves coming together to improve good practices and so on. And the American Correctional Association established a sub-body, the Commission for Accreditation on Corrections, and the Commission for Accreditation on Corrections was subsequently put at one remove from the American Correctional Association to give it at least a greater appearance of independence. And what that body does is to go around, visit institutions, primarily in a paper exercise, look at their rules and procedures and various facts and figures that are provided by the administration, and they accredit the prison, sometimes with suggestions that it needs to do further work on some issues. I just want to end, because I've got to end now, with the case of death row in Oklahoma. Again, this refers to some work that I did with Amnesty International, rather than my research. But I was invited to go to look at death row in Oklahoma, and our report on that prison was firmly of the view that it did not meet international standards and in varying respects amounted to cruel or unusual punishment. This was a Supermax type facility, and the kinds of stories we heard involved prisoners on death row, mentally ill, suffering from paranoid delusions, in which the guards were routinely using the intercom to say things like, "This is God speaking, do such and such." There were all kinds of horrors. The Commission for Accreditation on Corrections, give it its due, immediately withheld accreditation, and it appointed its own commissioner to revisit the prison and to re-examine things in the light of Amnesty's report. And that report ended, I haven't got it on the slide, and I'm not going to be able to find it in my notes, but it's pretty deeply imprinted on my memory. It ended with a statement that went roughly as follows. In this report, you will find nothing of the philosophy behind prisons. You will find nothing about international standards or international bodies. This prison is run by the Department of Corrections in accordance with their rules and regulations and in accordance with the law of Oklahoma and the United States and in accordance with the will of the good citizens of Oklahoma. End of story. So the United States, both at federal level and at state level, is remarkably resistant to international measures in these areas and has done rather little by way of establishing its own mechanisms, which it could be expected to have done given its ratification of the covenant, of the convention rather, and which many European countries have done. Okay, there I am going to have to end. Thank you for your attention. Obrigado. I hope we can have some discussion of the Brazilian situation in questions.